important sources of income, especially those who have families to support. Unfortunately, many people lose their jobs on grounds that are not valid or are not allowed by law. For instance, some employees are fired without due notice or without any valid reason.
With the unemployment rate up last July 2012 from 6.9% to 7%, it is very unlikely that the unemployment problem of the country would ever go down should employers continue to illegally dismiss their employees.
What are the legal grounds for dismissing employees? And what procedures must employers observe when firing employees? And finally, what can employees do when they are illegally dismissed from work?
Good evening, I am Attorney Karen Jimeno and you are watching Legal Help Desk on the Solar News channel. This show is about making the law work for you by giving legal advice on topics that matter to you.
And I'm Attorney Rod Nepomuceno. Tonight, we will be discussing on the issue of illegal dismissals. What you need to do if you think you've been illegally dismissed by an employer and what you need to do if you want your old job back. Yan. Wow, exciting. This is one of the most exciting parts of law.
Exciting and most contentious area of the labor law. And I think this is very important because we're talking about employment. This is the source of income, not only for individuals, but especially for those who support families. Because basically, this is their source of livelihood.
And in a way, this is a little tough. No? When I was practicing in our old law firm before, the tough part there is that normally it's a David and Goliath kind of scenario. Because normally, it's a company versus an employee or a group of employees. And of course, in terms of resources, the company has more resources, more lawyers, and so it becomes a little bit tough. And that's the reason why in law, the law is always favoring the employees.
Not favoring in a bad way, but more of providing more protection to employees. Because the assumption is the employers have more of the monetary power and also the resources to protect themselves.
Yeah, I guess yun nga, kung may vagueness, as they say, there's vagueness in the law, it's always interpreted in the favor of the employee. So that's I think that's the first thing that our viewers know, especially if you're an employee, that you should know is that in that scenario, normally in situations where there are cases between you and your employer, know that the laws are going to be construed or interpreted in your favor. But that doesn't mean that just because of that you can do anything illegal or wanton during the. So you have to be really careful on that.
So now let's answer some questions from our viewers. Our first question comes from Carlos, and he asks, I have my share of tardiness and absences, but not to the point that I should be given a notice by my boss or HR. But then, when we were assigned to a new boss and upon seeing my records, he suspended me. What should I do? Shouldn't I be given a warning or a less harsh punishment?
Yeah, I think in this case, I think in all legal situations, including labor law, of course, what's important is fairness and due process. And in this case, notice is required. It can't just be...
Of course, first, he should check what does your company manual provide. Because if this is really a ground for suspension, then check. Kasi, it's also management prerogative for employers to provide what the rules are.
But in this case yata, walang notice at all.
So one is for him to check if there's ground for you to be suspended on this basis. But even if there's ground for you to be suspended, one thing that's required is also due process. That means kailangan you should have been notified that upon review of your records, they've found grounds for you to be suspended, and they should have given you an opportunity to explain. To explain why you were late or if you should be suspended bago sila magbigay ng penalty. But then, if it's really not a ground for even suspension, then you could argue that you shouldn't have even deserved suspension.
So, importante, basta notice is always important. It can't be parang just suspension right away. No? So we've got an interesting topic. We've got a very
Yes,
important guest tonight. So
Yes,
let's
and
start.
we will be, of course, advising you on how to deal with situations if you are illegally dismissed or how to avoid it to make sure that your employers don't take advantage of you.
Yeah.
Okay, so let's take a short break. Legal Help Desk will return after these reminders.
Okay.
This is Vjoy. He and 6 of his colleagues were employed by the Timeless Group Unlimited, a BPO company based in the Philippines. He and his colleagues were dismissed by Timeless Group recently without any notice or an opportunity to be heard.
Nag-text ako sa admin namin, admin manager, mga November 16. Sabi niya, naka-receive ako ng text na don't report first to work. So, kala ko terminated na or something. So, nag-text ako sa mga co-workers ko. Then, I found out na wala pa pala yung sweldo. Tapos, yun na, mga December 19 na nalaman namin na sabi niya magpa-file daw for closure. Before that, nag-file na rin ako sa labor. Kasi medyo matagal na Tsaka bakit for closure? Nang walang notice. Normally, dapat, di ba, may like 30-day notice. So, nag-file ako. Mga 7 kami nag-file nun. Tapos, yun na, after filing, saka ako nakuha yung pera. I filed for money claims and illegal dismissal. May nagsuggest sa akin from the labor na tumawag ako sa Makati branch na to ask kung may notice for closure daw. Nalaman ko wala naman final na closure yung company namin. And I found out also na 7 kami tinanggal pero meron naiwan na 3 pa. So it's still ongoing until December 15. Siyempre medyo malungkot kasi magki-Christmas una-una. Yung nakuha mo lang yung half month salary mo which in-expect mo pati yung 13th month. Medyo parang yung mga plinano mo for Christmas nawala dahil nawala yung pera din Posible ba yon na verbally lang sasabihin ng kumpanya na foreclosure? Let's say, ngayon sinabi ko sa'yo na foreclosure tayo, wag ka na pumasok. Pwede ba yung ganon? Or kailangan yung mag-render ng ilang days bago ka talaga umalis ng office? At yung mga benefits or compensations, dapat ba makuha mo din?
You are still watching Legal Help Desk on the Solar News channel. Joining us tonight is Attorney J. Oswald B. Lorenzo. He is a professor of law at 7 law schools, including San Beda and San Sebastian. He is also the president of the Center for Law Advocacy and Specialized Studies, or CLAS. Welcome, Attorney Lorenzo.
Welcome, Attorney Lorenzo. And also with us is Vjoy Topacio, whose case we just saw on the video shown earlier. Welcome, Vjoy.
Good evening.
Ayan. So good evening. So Attorney Lorenzo, your initial thoughts po on the case study of Vjoy.
Okay. I observed that he works in a call center. And maybe the primary consideration there is whether he has a contract with a term. Okay, that's the first
Do you have a contract with a term?
Yes, I did sign a contract, but it states that after 3 months, it would automatically be renewed.
Renewed. Okay. So, from the time na hire ka, which was when?
October 17th, 2011.
Okay, that was last year. Na-renew agad siya. And what's the term? Is it automatic renewal all the time?
Automatic renewal, yeah.
Wala kang bagong sinay na
wala,
contract. Okay, so it's
So I'm sorry, it's
I think
for a period of how many months?
3 months
after
before.
3 months, I'm going to be regularized, and it's going to be automatically renewed.
Okay.
So the contract was for 3 months and then automatically
Yes.
renewed. Okay.
So I think he's been regularized.
Yeah,
If he's
kasi-
been working since October of
Last year pa.
2011, last year.
Now you were saying that 7 of you got
Yes.
affected, but 3 were retained. But how many employees all in all?
I think more or less like we were 18
18.
employees.
Okay. All right. So yeah.
But one thing I'd like Attorney Lorenzo to help us explain would be yung concept ng authorized cause for dismissal.
and
Because
yes,
you mentioned that they said that they
They're closing.
told you to stop reporting for work because they were closing
They were,
the
yeah,
business.
filing for closure.
And in the labor code kasi, this is really one of the grounds for an authorized cause for dismissal. If you're closing the business because of business losses. Because you're, of course, as an employer, the government is not forcing you to operate kahit nalulugi ka na. But then, what is odd here is that they were able to retain some employees, and I think it's still an ongoing business with a few employees. So it's not really closure.
No, tsaka the research, eh. May
Attorney
research, di ba?
Lorenzo, maybe help us explain this to Vijoy.
Maybe their case is downsizing because the company allegedly is losing. Okay, so that's their case.
It wasn't a case of closing, not a case of
It
closing.
was not a case of closing, so the size of the number of employees was only downsized.
Yeah.
Okay.
This is also called retrenchment under our labor code, right?
So that is the third kind of authorized cause, because the first cause is redundancy resulting to abolition of position.
Redundancy meaning you have employees performing similar functions.
Same or similar functions, yeah.
It's now a surplus age. You do not need those services anymore. The second ground would be automation, introduction of labor-saving device, or what is known as robotics. That's another authorized cause. Okay.
So, with Vijoy's case, it looks like this is a case of retrenchment or downsizing. Retrenchment to
Downsizing.
prevent serious losses. Assuming that's the ground, walang notice, di ba? Parang, I
Yeah.
mean, walang...
It was a text
biglaan
message.
na lang, yeah. And
Text message is
in
not
our
considered
law, how many days is the required period?
Okay, according to Article 283 of the Labor Code as amended, at least 30 days prior to effecting the authorized cause.
Yes.
Like laying them off from their jobs. So if there is a violation of that 30 days prior notice, that means a violation of due process.
And the consequence would be, what is the remedy of Vijoy and his other colleagues?
Okay, and assuming that the authorized cause is valid, he's entitled to at least nominal damage of 50,000.
Okay. Now,
Is-
it seems that yun nga, they were saying it was closing. Di ba? That was the Now, assuming nga that it is closing, what proof that does the company have to show that it is actually closing? I mean, that justifies the dismissal.
Yeah, because you mentioned that the labor arbiter asked you to check sa RTC Makati kung meron ba talagang final. But I think in all cases, you don't really file automatically. If you're closing a business, you don't necessarily file right away with the court. It's not the only proof, right?
Yeah.
Yes.
What can they ask for as proof here?
The proof of business losses would be at least 3 years financial statement. If it reflects a loss, the sad thing here is they are not entitled to any separation pay.
Okay.
Because that is due to serious business losses.
Yeah.
Okay.
But if the cost is not due to serious business losses,
Yes.
like some other causes, like non-renewal of contracts and so on, they're entitled.
So-
This separation pay is how much?
1 month. So
1 month
according
for
to
every-
283, the lowest under the authorized cost is at least 1 month, isang buwan, or 1 month, whichever is higher.
1 month for every
For
year
every
of
year.
service, right? Okay, you've been around in the company for 1
1
year,
year,
right?
yes.
So you're entitled definitely to 1 month separation pay if it is if the grounds for them to fire you or dismiss you, and your other colleagues is authorized cause because either yun nga nalulugi yung company. And also because of retrenchment. Pero if it's serious business losses, then no separation pay.
Yeah, but in this case though, and I'd like to qualify, kasi you were asked, diba, why did you check if there was a filing of a closing of the business? And there wasn't. But that doesn't necessarily mean that they're not suffering serious losses, right?
Yes, yes.
That's not, in other words, it's not required by law that there was a filing of
it's
of
not a
closing
requirement.
business. Yeah. So as long as the company, I guess I'm being the devil's advocate here on the employer side. No? Let's say they haven't really filed a closure, a closure of business. As long as they're really suffering losses, it could be a justified dismissal.
But
right?
another thing I'd like to discuss here is the process you underwent in order to get any remedy, also to help others who have been illegally dismissed. So first, you can file. What you did here is to go to the labor arbiter, right? In the NLRC, National Labor Relations Commission. So, Attorney Lorenzo, siguro for others like VJ, maybe you can help us step by step kung ano yung remedy.
Okay, first, what he did was to go to the Dole Regional Office. And later on, he was advised to file his case with the NLRC. Okay. Under our labor courts, for example, the claim is less than 5,000 pesos money claims without illegal dismissal, the regional director has jurisdiction. So outrightly, any complainant must be informed of that level. But if your action is for illegal dismissal plus money claims above 5,000 pesos, then go directly to any of the regional arbitration branches of the NLRC. Okay. And then it will be ruffled to a labor arbiter.
Okay.
I see. Okay.
And then kung, just in case, I hope this doesn't happen, kung matalo sila sa level of the labor arbiter,
Then
what's their remedy?
Okay, within 10 days from the receipt of the decision by them or their counsel, they can file an appeal with the NLRC. So it will be ruffled to the NLRC division.
How many, ano yung period nun?
Within 10 days, 10
okay.
calendar
Yeah.
days from the
And
receipt.
then from there, assuming matalo ulit sila, then they can already,
Another motion for reconsideration,
okay.
10 days after the receipt of the decision. Then after that, within 60 days from receipt of decision, they can go to the Court of Appeals
Yeah.
under a petition for certiorari under Rule 65.
Yes, okay.
Then, if
Pag
they
hindi
still
pa rin,
lose, MR, another 15 days,
Supreme
CA,
Court.
and then Rule 45 next.
Supreme
Within
Court.
15 days to the Supreme Court.
Just also for the benefit of other people situated as VJoy, you didn't need a lawyer, right? Hindi mo kinailangan ng magsama ng abogado in order to file this complaint.
No, hindi na.
So, for those of you who have problems with your employers, kunwari you feel that you were illegally dismissed, hindi to for a just or authorized cause, then you can go to the labor arbiters in your regional office. And you don't need to bring a lawyer with you.
May tutulong naman. Yan, okay.
And one thing pala, lastly, yung tungkol naman sa, just in case we find that hindi naman pala totoo na kailangan nilang mag-retrench ng employees or mag-downsize, other remedies of VJoy would also be payment of back wages,
Back wages.
right? Or reinstatement. Can you
Reinstatement
discuss
plus
this
back
further?
wages.
Attorney
Because there was no
Lorenzo?
just cause.
When an employee is illegally dismissed, then reinstatement is a relief. Plus full back wages up to actual reinstatement.
Okay.
So, VJoy, just in case hindi totoo pala na kailangan nila mag-downsize, there's no legal basis for it, it was carried out in bad faith, then you can ask for payment of your salaries. Na-mention mo nga na you were expecting your 13th month pay. You should be able to get that from the time na tinext ka, na hindi ka na pumasok, up to the time na ibalik ka nila sa trabaho mo.
From a practical standpoint lang, one last question. While this is going on, he can work. Di ba?
Yes, he can
should
work.
be able to work, and that's not going to be taken
Yes,
against him, right?
it
Because
cannot
I think that's also important, di ba? Kasi obviously you're complaining now, and you're not legally employed. You're not gainfully employed. So I think that's important to also say to our televiewers that you can look for a job.
Supreme Court already decided that.
All right.
Hey, sorry guys, I have to cut you short.
Alright.
Konti lang yung time. Thank you, Attorney Lorenzo, for joining us and enlightening us on our labor laws, especially on the issue of illegal dismissal. Thank you also, VJ, for sharing your case with us.
You're welcome.
And now, Legal Help Desk will return after this short break.
When working for a company, whether big or small, it's always important to be a professional.
That way, your employers will not have any reason to dismiss you untimely. Take note, you can only be dismissed by an employer if you've committed the following. Number 1, serious misconduct. Number 2, willful disobedience to lawful orders. Number 3, gross and habitual neglect of duties. Number 4, fraud or willful breach of trust. Number 5, commission of a crime or offense. And number 6, analogous causes. Analogous causes can be very broad. Here are some examples. Number 1, abandonment of jobs. If you have purposely left your job without any intention of going back or knowledge of your employer. Number 2, gross inefficiency, committing acts that resulted in damages to the employer or his business. Number 3, disloyalty or conflict of interest. And number 4, dishonesty. So remember to always behave while in the work area. A job is hard to come by these days, and consider yourself lucky to have one.
You are still watching Legal Help Desk on the Solar News channel. Let's answer a few more questions from our viewers. Andrea asks, I work as a call center agent in Quezon City for a year now. Ever since, my TL has never liked me. I don't know why. One day, she gave me a piece of paper stating that I will be transferred to our company's branch in Alabang. She forces me to sign it or else she will fire me. Can she do this?
Ayan.
So first,
Okay.
ano ba yung TL? True
Yeah.
love?
Oh, true
Or
love
I guess,
or team leader? Team leader,
I guess
yeah.
team leader.
Okay.
But one thing here, Andrea, you cannot be threatened to be fired kung hindi ka mag-transfer unless, first, let me start by saying pala, a transfer is normally management prerogative, especially if this is required based on what the company needs. I don't know where you live, if an Alabang transfer is going to be very, very inconvenient for you, but you have to follow the transfer if it's really required for business reasons. But then, if there's bad faith, I don't know what your basis is for saying na she hasn't liked you from the start, but if you can prove that this was because of bad faith na ginawa niya lang to dahil inis na inis siya sa'yo, then you can refuse to transfer to Alabang because obviously this was not made for business reasons or for the good of the company.
Yeah.
And you cannot be fired for doing that because yung other scenario would be if this is a valid transfer and you refuse to follow it, then it can be a ground for a just cause for dismissal, meaning it can be considered as willful disobedience of the lawful orders of your employer. So, I'm sorry if I cannot give a categorical answer
Yeah.
because this is factual,
Yeah.
Based on a factual
Yeah, there have been
question.
cases I know. There have been some cases where the employer, out of its own willful decision and with a little bit of malice, would appoint an employee, let's say from Manila, and then appoint them to a branch in Tuguegarao and clearly, or some other place, no? And it's clear that it's not a practical transfer. It has no business logic to transfer that person, other than the fact that they're pinag-initan siya. No? And that if that's the case, then she might have something to work on insofar as building a case is concerned. But otherwise, a transfer is generally valid.
It's a management prerogative. So,
yeah,
Andrea,
yeah.
I suggest that of course you check
Yeah.
if there's really a valid reason to transfer you to the Alabang branch. If there is, then this is something you have to follow. Pero if you can show na pinag-iinitan ka lang, then
Yeah.
you can refuse to transfer there and this should not be a ground to dismiss you.
Yan. Okay, our last question comes from Marga. She asks, I am newly employed by an online shopping company. While reading their contract under attendance, it said that after accumulating 3 unauthorized or unexcused absences, it will be regarded as abandonment. Is this correct? Ayan. So it's based, usually in these cases, management does have the prerogative also in deciding the policies that they'd like to enforce with respect to attendances, absences and
pagiging late,
pagiging
right?
late, the tardiness. No? So in this case, I don't think that that's totally illegal. Again, it's case to case, and as
Yeah.
you mentioned earlier, Karen, it's factual. No, there are some companies that are very strict on tardiness, especially when your job does require you to be on time. No?
Yes. But also, of course,
Abandonment kasi can have legal implications. There have been Supreme Court decisions which say na, for instance, if an employee files a case for illegal dismissal, that refutes yung assumption na merong abandonment ng trabaho. So, there's always an opportunity for employees to contest if they really abandon their work, even if, of course, this is provided by the company manual. Kasi ibang-iba naman yung abandonment from just absences and the penalties for being absent.
Oh, you're right. And minsan, there's also the question of what is authorized or excused absences. No?
Yes.
But like I said, minsan it depends also on the nature of your job. No? Like in our case, like in some companies like advertising, they come in late all the time. No? And then, but there's some businesses where very essential that you're on time. So sometimes the manuals are more strict. So we have to consider it on a case-to-case basis, as Attorney Karen said. All right, so that's all the time we have for tonight. We would like to thank our guests for coming and giving us a more in-depth explanation on our country's labor code on illegal and legal dismissals. I'm Attorney Rodney Pumoseno.
And don't forget to like us on Facebook and follow us on Twitter. Join us again next time on another round of discussion on your legal rights. I am Attorney Karen Jimeno. Good night.